When a relationship ends, everything can feel messy emotionally and practically. A separation agreement is one of the tools that helps put some order back into the situation. In Ontario, these agreements are governed by the Family Law Act, and they can cover property division, spousal support, and parenting arrangements. But they only work the way they're supposed to if they're drafted and executed properly. So in this video, I'm going to walk you through what a separation agreement actually is, what makes it enforceable, the legal test courts use when support waivers are challenged, some common pitfalls to watch out for, and a few practical drafting tips you can actually use today. What is a separation agreement? A separation agreement is essentially a private contract between former partners. It usually deals with things like the equalization of matrimonial property, spousal support, including support waivers, custody and access arrangements, and child support. Just keep in mind that child support waivers are never enforceable in Ontario. The law doesn't allow you to waive child support. And once a separation agreement is properly signed, it doesn't just disappear when you get divorced. The agreement stays enforceable unless a court decides to set it aside. Divorce alone doesn't cancel it. For example, imagine a couple signs a separation agreement that divides their family home and includes a spousal support waiver. If one person later claims that they signed the waiver under pressure, a court will go back and look at the fairness of the waiver. It might uphold it or it might set it aside. It really depends on how the agreement was made and what the circumstances were. Here are some formal and procedural requirements. For a separation agreement to be legally valid in Ontario, it has to meet a few minimum requirements. It has to be in writing, it has to be dated, it must be signed by both parties, and the signing has to be witnessed. Now, beyond the basics, it's strongly recommended that each partner gets independent legal advice, also known as ILA. Before signing, it's not technically mandatory, but it massively strengthens the arrangement because it shows that each person understood the legal consequences of what they were signing. Here's a practical tip. If you're recording the signing or documenting the process, have both people acknowledge on camera that they had the opportunity to get legal independent advice and that they understand the terms of the agreement. Now for the Miglin test. Here's how courts assess support waivers. When someone tries to challenge a spousal support waiver, courts don't just look at the document and make a quick decision. They go through a detailed two-stage framework called the Miglin test. The first stage looks at the procedural fairness. Was the agreement negotiated voluntarily? Was there full financial disclosure? Did both sides have independent legal advice? The second stage looks at the substantive fairness over time. Are the terms still reasonable given any changes in circumstances? And do the terms line up with the objectives of the spousal support under the legislation? If the waiver fails either stage, let's say someone hid assets, or there was no disclosure, or the terms were simply unconscionable, the court can set the waiver aside and order support. Here's a classic example. If one spouse agrees to a total waiver of support, but they didn't know the other spouse had significant assets, that waiver can easily be overturned under Miglin. Here are some common legal issues that often go unnoticed. Now, even when people think they've done everything right, there are several issues that often undermine separation agreements. Incomplete financial disclosure is a big one. If assets or debts are hidden, a court can set everything aside. Signing under pressure or during a period of emotional or financial distress is another red flag. Agreements with unconscionable terms, things that basically shock the conscience, like totally excluding someone from the equalization process, are also vulnerable. A lack of independent legal advice or getting advice too late makes the court question whether the person truly understood what they were signing. Informal amendments, for example, changing terms through text messages or verbal agreements, can also weaken the whole document. And again, Child support waivers are never enforceable, so those clauses are ignored automatically. Delays in challenging the agreement can also hurt your case. If you discover a problem, the court expects you to act promptly. A great recent example is the case of Yin versus Feng in 2024, where the court looked closely at disclosure and independent advice, and the party who waited too long to challenge the agreement didn't do so well. Here are some practical drafting and enforcement tips. If you want your separation agreement to be as strong and as enforceable as possible, there are a few practical drafting steps that make a huge difference. Use full appraisals and attach proper schedules. Include property valuation and a complete signed list of assets and debts and incomes updated right before signing. Include a clause confirming that both parties received and reviewed full financial disclosure. Add variation or review clauses that kick in when major life process events happen. Things like a significant income loss, a serious illness, or a major shift in parenting circumstances. If your agreement includes support provisions, file them with the Family Responsibility Office so they're enforceable through the civil system. And if you ever need to amend the agreement, do it in writing, have it witnessed, and ideally get independent legal advice again. A quick practical step for reviewers: create or download a checklist that confirms the agreement is dated, signed, witnessed, includes full schedules, and clearly states whether each person received independent legal advice. Overall, separation agreements are incredibly powerful tools, but everything rests on fairness, full disclosure, and proper formality. If you're negotiating one, document everything, get independent legal advice, make sure your schedules and review mechanisms are clear and complete. If you want a template checklist or a short guide you can bring to the negotiation table, click the link in the description to download our client checklist or to book a consultation. And if you found this video helpful, don't forget to like, subscribe, and leave a question in the comments. I'll be answering the most common ones in a follow-up video.